Yes. So I started with you on the unjustified enrichment number one, where we're talking about the requirements. And I told you about the requirements right after the meaning of the estoppel. And I showed you all the requirements, and I talk about that the question will come sometimes based on particular requirements. So you must be able to spot that this question is talking about this requirement. Number one, I told you that we have misrepresentation. There should be a misrepresentation. And number two, we have the fault. And we have the prejudice, we have a causation, and they should be permissible by the law. Those are the requirements to rely that they must be proved. Now, remember the delict. On the delict, we say that we have those requirements that must be the elements of a delict that must be proved. Like we have a conduct, we have the fault, we have the wrongfulness, we have the damage, and so on. Those are the elements that must be proven. So even here, there should be requirements that must be met that we can prove that there was indeed you can rely on the stopper because there was this things. So it doesn't mean that you just raise the stopper because you believe that there's a misrepresentation. They come and look at the misrepresentation. So today I said that we are talking about the misrepresentation, looking at that question that we have done yesterday. And I said, in the misrepresentation, if you are director of the company, the people assume that you have a right to enter into a contract. Everybody just assume that you have been authorized because you are director, and by being a director, it gives you much power. So director run the company day to day, right? Although there's a non-executive directors. Now you find that you go to that company, you enter into a contract with the person, with the director, and then the shareholders of the company say, "No, we are not bound by this agreement." Why? Because that director was not authorized. Now we know that we have the Tangled rule that will take place if we're talking about the company. But now the estoppel can be also be used because there is a misrepresentation in terms of representation. Who is representing? When you are representing, you must know that you have a duty to speak, as I have said. That misrepresentation can take place even on the omission, and then it can also take place when they're testing. They check the legal view of the community, which we call a bonimors. Sometimes where we check the legal views of community, or whether when we check whether there will be a misrepresentation, whether the party will be misrepresented, which we call it a bonimors. It's something that you have done in Tilict about that one. But today I'm more of the duty to speak, which is the misrepresentation by positive act. Now, a person should act positively. Failing to act positively, it means that you have misrepresented by someone by omission. Just like the director of that company, the director should decide, I am not authorized to to enter into this kind of contracts, or to enter into those contracts. But failing to say I am not authorized, it means that there is a omission. I mean, the company has entrusted that person, and it's up to that person to speak and duty to care. Remember when we were doing the delict, I gave you an example of a mother who said nothing about the father abusing the child, beating the child, and she said nothing. And she was found guilty because of a duty of for omission, because she failed to act positively and to alert the people, or the law enforcement agencies.
All right. So now, because I'm starting to have questions on this one, ne?
Yes.
Let's see, a scenario comes and it's based on misrepresentation. It means then it means that I must be able to check how the person was misrepresented. Was it by omission or was it by representation? representation, ne?
Yes,
So when,
but
meaning when I answer, I
you,
must show.
you may
Okay.
find that there was a fault on that question. So it depends on the question. Let me try to open up some of the questions so that we'll be looking at those questions. Okay, now let's look at this question paper, right? It says that A takes his car to B, who sells second-hand cars, to have his car valued. A leaves the registration papers of the car inside the vehicle. The car is parked on B's showroom floor where it is left for 3 days. During this period, one of the sales staff, X, who believed the vehicle to be part of the stock, sold the vehicle to C for cash. A now claims the vehicle from C with the relevant case. Advise C fully with reference to the relevant case law. Now, if you look at this question,
There's fault and misrepresentation.
there is a misrepresentation, but that misrepresentation is not the of a represent the person who thought, it's not like a director that I go to the company and said, can we enter into this agreement? We enter into a contract while the director knows that I'm not authorized. That is another part of the misrepresentation by representation, where the representation misrepresent you. Now, this person, the X, who is the staff, is just he's in believing that this car, because it is parked here with other cars that are on sale, this car is on sale. So it means that the person who parked the car misrepresent X and acted on that misrepresentation to sell the car, right? Because B parked the car and misrepresented X. X then acted on the misrepresentation and sold the vehicle to C.
Yes. So can I try something here? You will correct me, ne?
Yes.
Now, X misrepresented the person who bought the car, which is C, right? On the other
No,
hand,
X acted on the misrepresentation. X never misrepresented C because X was misrepresented by B, who left the car where the car is on, where the other cars that are on sale, right? It's like you have a goat. Let's just say goats or sheep. Let's just say you have a sheep. Now, there are those goats that are on sale and those that are not on sale. Then you take one of the goats that is not on sale and you put into those goats that are on sale. The person, your worker, you never alerted anyone. Your worker will just assume that all this, because there are goats that are on sale, it means that the person will sell that goat. It means that the person will act on your misrepresentation and sell. So the staff is misrepresented by you, who failed to alert them that there is a car that is not on sale that is parked there. So B should have told the X, but B couldn't tell X, meaning X was misrepresented by B, and X acted on the misrepresentation to sell the car to C. Therefore, X never misrepresents C. X just acted on the misrepresentation, believing that the car was on sale. So it means that when we look at the requirements of estoppel, we look at the fault. So there was a negligence on the part of B, because B should have alerted X, and B was negligent, and therefore, as a result of that, X acted on the negligent.
Mr. Munyaine, in my understanding, I do understand that there was fault and there was misrepresentation. But then I was going to say fault was on the part of the person who left the documents of the car inside the car without telling other people that it's not on sale. I was going to say A there was fault on the part of A for leaving the registration papers of the car inside the vehicle.
Yes, but remember, the place is for B, and it is for B who must check that this car on sale, those are not on sale, and park the car to the rightful. Another issue is that B is the one that must inform the staff that that car is not on sale. So that is the duty of B, because the person has taken his car to B, who sells second and to be valued. So B should have said that this car is here to be valued, and then it's not on sale. Because I cannot just take a car to you without any agreement. So it means that when I arrive there, they arrive and give to B, and then they park. B shows that you must park there, and then they park the car where the those other cars that are on sale. So B has a duty to inform the staff that that car is here to be valued. Don't sell that car. But he there was a
Now,
omission on his part.
okay, I want to ask you something. Isn't that this question was for 50 marks? And when we discuss it, I need to at least make sure that we get closer to 50 marks. Ne? I want to understand something. Meaning, when answering this question, I'm supposed to say X act on the misrepresentation caused by B for failing to act positively, or for by misrepresentation by omission for failing to inform the staff that the car was actually not on sale, right?
Yeah, but remember, the question is asking that A wants to claim a vehicle from C with revindication. So the car that they're asking if the revindication will be successfully. So as I've said, that this is the issue of negligent. B was negligent, where he should have informed the staff that the car that A brought is on it's not on sale, it's just here to be valued. Then it means that there was negligent on the part of B.
And for C to succeed with revindication, he
No,
must
A is the
first
one
pay
that
the
wants
person.
to A is the one that wants to raise a
I mean
revindication.
A.
Yes,
For
but
A to
remember,
succeed with revindication, he must first pay the person who bought the car.
yes, he must first pay the person who C who bought the car, because C is a third party that know nothing. So the issue was the issue of the dealer, that someone from the dealer like B should have acted positively, but the person failed, leading to negligence, and the staff acted on that negligence, and therefore there was a sale to C. Therefore, A can claim with revindication, but C will raise estoppel, and then now they will go. I told you about this one. So this issue, if we go back to the book, it's not the issue of a misrepresentation here. It's the issue of a fault, where there was a fault on the part of a B. So we look at the fault.
You're confusing me.
Yes, that's why it's the
You're
same statement
confusing me,
here.
Mr.
They
Munyao.
say that A leaves his car for repair with B, who services cars in his backyard and who also sells second-hand cars from the premises. A forgets the original registration papers of the car in it when he leaves it with B for repair. B repairs the car but leaves it standing next to other old cars that are for sale. C shows an interest in buying the car, and B's wife, upon finding the registration papers in the car, assume that the car is for sale and sell it to C. Will C be able to plead estoppel successfully when A claims his car with revindication? So it's the same question, that one, and it's talking about the one that I said, the successfully reliance on estoppel. Now, when you look at this question, it means that B was negligent on his side, because B should have not left the car with those that are on sale. He should have parked the car somewhere where there are the cars that are maybe where those cars that are repaired, they are parked, the area where the repaired car parked, maybe there, but he was negligent and just left the car. So it means that it was the A who leaves those papers. We can't just blame him because he left the car in the hands of B, and then B repairs the car, but he parked the car with those that are on sale. Therefore, B's wife was misrepresented by B's. It means that B's wife acted on the B's misrepresentation because B was negligent and sell the car to C. So will C be able to plead estoppel? Yes, C will able to plead estoppel because C have bought the car fair, equally, and square. And then it's just that there was a misrepresentation. The person who was misrepresented is B's wife, and not and also C was misrepresentation as a result of the B's wife acting on his misrepresentation. And then I said that this issue, yes,
isn't that I want to be honest with you, ne?
yes,
Isn't that actually I just realized that memorizing all these things is going to waste time for me, right?
yes,
Now, right now it means you are teaching me how to pass, ne?
yes. That's why I'm telling you that it means that when you answer, the first thing that you must know is the test for negligence, which I have taught you. So the first one is that be in that situation. B, if a reasonable person in the position of B would have foreseen loss or prejudice to the deceived, which is a B's wife, and would have taken steps to prevent the loss. If the deceiver either did not foresee loss or did not take necessary steps to prevent it, the deceiver is regarded as having been negligent. So it means that this applies here on this situation. B should have foreseen that his action will lead to a loss because someone can just sell that car. But nevertheless, he never took we never prevent that loss. So it means that B was negligent, and therefore it means that C, as a result of the negligent test, he can be successfully with his stopper. So it's the same question that we have been. The question is all about talking about the test for negligence. If a reasonable person, which is the B, in the position of the deceiver, would have foreseen loss or prejudice to the deceived and would have taken steps to prevent the loss. And if the deceiver either did not foresee loss, did not take a necessary step to prevent it, then the deceiver is regarded as having been negligent. So B's wife was been deceived, and therefore there was a loss because she acted on that negligence and she sold the car to C. Therefore, C can able to raise a stopper. C has bought the car. There was the papers inside the car, so everything was there. So C just bought the car and then signed. Everything was good.
Can we please go back to the first scenario, not the very first one, the one that we were doing of A and C for the one person who packed and it got sold. Yes,
You
this
mean
one.
this one? Yes, this
Yes.
one is the same. B is the same person. Remember, A takes the car to B. So B is has passed the negligent test because he, as a reasonable person, should have seen that the parking in a showroom floor where they are selling, there's a sale of stuff. There's some stuff can be misrepresented and sell that particular stock. So it means that B should have done better in that position, and therefore it means that B misrepresented X, and B was
I want to
negligent.
sorry for interrupting. I want to ask you as to, based on this scenario, which requirements are there when we look at this scenario, Mr. Munye?
Remember, the scenario is not talking about requirements. It's talking about whether it's asking about whether A can claim the vehicle from C with revocation. Remember what we have said in the property. In the property, we said that when we claim with reivindicatio, the property should be, now let me go. So you remember the reivindicatio, as I've said, the reivindicatio made it clear that the person must be the owner and the thing must be existing and identifiable, and the defendant should be in control. So if all those are available, it means that the person can successfully rely on reivindicatio. But here's the problem. Is A still the owner? No, there was a change of papers. A is no longer the owner because the person who bought the car, there was a change of ownership. So A is no longer owner. We heard that the person has left the papers, right, in the car, and then they changed the ownership, of course. So the car is still existing and is still identifiable. And of course, the person, the defendant, is in control. But here is that the person is not the owner, or we can say that there's an argument whether he's still the owner or not. So this argument meaning that there's the reliance on rape vindication will not be successfully because the other person will raise a stopper, and then the court has to determine who is still the owner. But remember, there's amount that has been paid. So if this person is proving that he is the owner, he must also pay the other person for proving that. So we can see here, if we're going to apply, that even though leaves the car and then he forget his original registration papers. So the was, maybe he has already signed, of course. So the other person has changed the ownership, and therefore C has a new ownership. Therefore, the C can able to plead stop. And don't forget that the delivery of movable is not more of a change in papers. It has to do much with the delivery. So there was a sale and there was a delivery. Therefore, C has bought the car, right? Yes. Those are the things. Those are the things. So don't worry when you get into examination. We will be, I will be telling you throughout this week and the next week um, how you answer those particular questions. Remember, I've sent you about that paper where I've answered the particular question, and therefore I've showed you on that one how you answer. So it will be easier for you in the examination. So these particular questions will come, and therefore you will know which one, and then you will know the case law because there are many case laws. Then you will just pick the one, then you go with it.
Okay. Yeah. We'll have to do more of these scenarios.
Yes, but don't forget that when you apply negligent, you look at the requirement in South African case law, how South African case law apply. So don't use the cases of a Roman Dutch laws. Remember, they start with some Roman Dutch laws if they've applied in Roman Dutch laws. You look at South African case, how they determine that test and how the test was applied. So you look at those one and then you know. So those the cases are many. You just pick the one that it's matching this the scenario. So the one that you feel like is applicable to the scenario, that is the one that you pick.
Okay.
Yes, right. So there's no problem with this one. Just that you must take time to understand, and then you will.